A very good afternoon to all my friends and LinkedIn connections. The issue which I am going to discuss today is that if suppose somebody has made an interstate purchase and has paid IGST. All my friends and LinkedIn connections. So if somebody has made an interstate purchase and has paid IGST on his purchases, then obviously he should take in his input tax credit ledger credit of IGST. But there are cases which I've seen that where suppose due to some inadvertent error or understanding of the law, the credit which would have been taken as IGST credit is taken as CGST and SGST credit. So suppose 100 rupees of IGST credit is accruing to me and I should have taken 100 rupees of IGST credit. Then instead of taking 100 rupees of IGST credit, I have taken 50 rupees CGST and 50 rupees SGST credit. So is there any mechanism in law through which I can rectify my error? First of all, if under section 16 subsection 4, there is a time limit prescribed to avail the credit. That time limit says that you can take credit within 31st of November of the coming financial year. So for example, if the credit pertains to 2023-24 and you are in July 2024, so you still have time to rectify your error. And what you can do is that you can reverse that IGST credit. Sorry, reverse that credit which has been inadvertently taken as CGST and SGST and take IGST credit now. I think we all know that there is no provision on the law to revise the return. So if you inadvertently take any credit in any month, there is no provision in the GST law to revise that return. There is a judgment of the Honorable Supreme Court in the case of Airtel, where this particular issue was raised, that if I suppose make any error in my filing of the return and make some incorrect entries, then I should be allowed to revise my return. But the Honorable Supreme Court referred to section 39, subsection 9, and it said that section 9, subsection So Honorable Supreme Court said that section 9, subsection 39 has no provision for rectification of the error. No provision for revision of the return. But of course, if you detect any error in filing of the return, any omission is there or any incorrect particular is there, then that you can rectify before the 30th day of the November following the end of the financial year to which such details pertain. So if you make any error in any filing of any return in any month, then instead of revising that return, the facility of revising the return, we know that the facility of revising of return was available in the Central Excise and Service Tax Law, and some of the state VAT laws also allowed revision of the return. But unfortunately, in the GST law, there is no provision for revision of the return. So only option is to rectify your errors and omission before the timeline prescribed in section 39, subsection 9. and section 16 subsection 4, which is 30th of November following the end of the financial year. So if your error pertains to 2023-24, then ideally you should reverse your credit in the month in which you notice the error. So for example, if the error has been committed in the month of March 2024, then you still have time till 30th of November 2024 to rectify your error in the return in the month in which you are filing your return. So for example, if you are filing your October 2024 return or July or August or September return, you can rectify that return in any month. But suppose the error pertains to period prior to 2023-24, then there is no provision in law to rectify such error. Now, if you have wrongfully paid the tax, for example, somebody has paid IGST instead of CGST and SGST, or has paid CGST and SGST instead of IGST, then there is section 77 of the CGST Act. There is section 77 of the SGST Act. There is section 19 of the IGST Act, which allows you to claim refund of the inadvertently paid tax and make payment of the tax which should have been made. So you can rectify the error in the making the payment in the head of the account. So IGST, if you have made any error, CGST made any error, SGST made in any error, where you have made any switching error, you can rectify that error. But there is no provision in the law to claim the refund of the incorrectly availed input tax credit. So if you have availed CGST and SGST credit instead of IGST, then there is no mechanism in the law. Only if you have a timeline available under section 16(4), you can rectify the error in the month in which you discover. But there is no mechanism provided in the law to correct the error. Now the question arises that why I'm discussing all this if there is no solution. But friends, in my view, there is a solution in the law, but that solution is not within the boundaries of the law. That solution we have to get by filing a writ petition in the High Court, because the powers of the High Court to rectify such error in the article by invoking the power under Article 226 is wide enough to condone such error and to rectify. Now, what should be our submission if we suppose file a writ petition telling the court that, look, I have made this error and now I should not be penalized for this inadvertent error, because obviously there is no intent to avail any benefit which is not eligible to me. The only error is in terms of the head under which I should have taken the credit. So here I think we should refer to section 17 and section 18 of the IGST Act. Section 17 says that if any tax is collected as IGST and if credit is not taken, then it has to be apportioned between the union and states where the supply is made. So we know that the GST is a destination-based tax, and therefore the revenue accrues to the state wherein the goods are supplied. So if suppose the goods are moving from Tamil Nadu to West Bengal, then the revenue, the tax will have to be apportioned, because any collection of tax in the mode of IGST under Article 269 capital A of the Constitution of the India, even though the union has the power and the responsibility to make the collection of the tax, but that tax has to be ultimately apportioned between the union and the state. And for that, there is a settlement of Fund Rule 2017, which outlines the procedure for apportionment of integrated tax between center and the state. And there is section 17 and 18 of the IGST Act also. So section 17 says that if the integrated tax is collected and wherein the ITC is not available, then the revenue will accrue to the state where the supply is made at the rate of tax equivalent to the state tax, and the central will get that portion of the revenue which is equivalent to central tax rate. So if suppose the total 18% IGST is collected, then 9% will go to the Union of India and 9% will go to the state to which supply has been made. So if the goods has traveled from Tamil Nadu to West Bengal, then 9% will go to the central government and 9% will go to the West Bengal. Similarly, section 18 is there, which lays down the manner in which the input tax credit is transferred, where the credit of integrated tax is utilized. Section 18A says that if the integrated tax is utilized for payment of central tax, then that portion of the integrated tax which is utilized as central tax will stand reduced by an amount equal to the amount so utilized, and the central government shall transfer an amount equal to the integrated tax to the central tax account. Similarly, if the IGST is utilized for the payment of state tax, then that portion of the integrated tax which is utilized for payment of the state tax will be transferred to the respective state government. So, on a conjoint reading of section 17 and section 18, Article 269A of the Constitution of India, it is evident that if any tax is collected as IGST, ultimately it has to be apportioned between the center and the states. And if somebody was eligible for credit of IGST and he makes an inadvertent error in taking the credit as CGST and SGST, then there is no loss of revenue either to the union or the state, because on utilization of the credit, they will get their revenue. So therefore, in my view, our submission should be, by referring to the section 17 and section 18, and also referring to Article 269 capital A of the Constitution of India, that such an erroneous filing of the return is a procedural lapse. It has not resulted in any detriment to the revenue of either state or the center. So it is a revenue neutral situation. Secondly, it is a settled principle of law that the substantive benefit cannot be denied for a procedural error. So the procedural error of filing an incorrect return, wherein there is no benefit, undue benefit has accrued, cannot be denied. We can refer to the judgment of the Honorable Supreme Court in the case of Commissioner of Central Excise versus Home Ashok Leland in the context of moderate credit, wherein the Supreme Court said that the procedural law cannot affect the substantive right of claiming moderate credit. It is a established principle of law that interpretation which unduly restrict the scope of a beneficial provision should be avoided, so that what is available to me by reason of the policy cannot be taken away because of the procedural errors. And in this connection, there is a judgment of the Honorable Supreme Court in Mangalore Chemical and Fertilizer Limited versus Deputy Commissioner, which was reported in 1991, 55th volume of ELT on page 437 that mere fact that a condition is statutory does not matter one way or the other. Some may be substantive, mandatory, and based on consideration of policy, and some other may merely belong to the area of procedure. It will be erroneous to attach equal importance to the non-observation of all conditions, irrespective of the purposes they were intended to serve. So, in my view, this incorrect filing of the return is a mere procedural error where there is neither any undue advantage accruing to the SSE, nor there is any loss of revenue to either union or the state. That is evident from the conjoint reading of Article 269A of the Constitution of India, read with Section 17 and Section 18 of the IGST Act, and the related provisions, Settlement of Rules 2017. So, in my view, on these lines, if we make our submission and defend our case in response to the reply to the SOCOs, then it will so happen that the assessing officer is not likely to give you any benefit of such submission because he is not empowered to go beyond the purview of the law. But ultimately, Honorable High Court is in most likely will condone such an error. And in this respect, there is a judgment of the Calcutta High Court also in Cosin Limited versus Assistant Commissioner of State Tax in MAT number 2411 of 2023, wherein the Honorable High Court of Calcutta granted relief to the petitioner in a similar situation. So with this, friend, I conclude my today's discussion. Thank you very much.